shining a light where the shadows creep, for the lost, the stolen, the ones who will weep. She won't turn away, she won't back down, even when the loony clowns come round. Threats don't shake her, lies don't win. She stands for justice, right till the end. Want the truth, want the best, wanna be safe as you chat. Find kids true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Chase fame, some chase views, but she fights for those with nothing to lose. For the kids who vanish without a trace, she won't stop till she cracks the case. They try to silence, they try to scare, but truth don't break and she's still there, calling out monsters, showing their game. Justice comes when you speak their name. Want the truth, want the best, wanna be safe as you chat. Find kid true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Need a voice, kids stand strong. She makes the choice for victims gone, for those in need. She's fighting hard, she won't concede. Want the truth, want the best, wanna be safe as you chat. Find kids true crime, it's worth your time. She's got your back, she's on the
What up, my peoples? Good morning, Misty. How are you doing? Are you laughing at something? You know what? I was shocked you made it. You want to know why? Because I always forget about the 2-hour difference. You're 2 hours behind me. I'm so sorry. Because if I text you, my bad. I forget. Thank you. I love that song too. My friend on here, Viper, well, he's everybody's friend on here. He wrote that for me. I'm always saying, I am too. I am too. I am too. Good morning. Oh, thank you. I appreciate you. You know what? I appreciate you and Misty. And, well, I appreciate everybody. But I appreciate 3 of you because you're always here for me. And I appreciate that. I really do. I really do. Even if I'm not doing Wade Wilson, you're here. Well, Misty, you're always going to be here. There's no getting rid of you. But you know what? There's more to the world than Wade Wilson. There really is. Look at Lori Vallow. She is my girl. Yes, people. Let's look at some documents real quick before we start. It's supposed to start at 10:30, but we're going to look at these documents. It is so old. So old. I am so sick of Wilson. And I'm so sick of wasting my money on him. Okay, so let the record reflect. Let the record reflect, it says. That Matthew Kelly presents argument on court on behalf of Court TV. Okay. Defense objects to the request and the state takes no position. Let's see. After discussion, the court will issue a detailed order which appeared late in this minute. Let's see. The court will hold jury selection and courtroom 5C. So what this is saying here, they're going to get 200 jurors, right? Will be sent out to the jurors on 3/24/25 to 3/27. The court will meet on 3/31 to discuss strikes and hardships. They will conduct an in-person voir dire, and that's on April 1st. Opening statements will be April 7th, okay, peoples? And not just that. Hold on a minute. Let me come to my... Do I got someone new here? Oh, hi, Marie. How you doing, sweetie? Okay. Let's get back here. Okay, so the trial starts on April 7th. Now, this is common sense, people. Jury selection, we're not going to be able to watch any of that. So anything for us will be on the 7th. It is ordered that the state shall file a joint pretrial statement, including a witness list by March 13th. Okay, we already know that. It is, okay, what is this? It is ordered granting the state's motion if the defendant believes the state has opened the door to introduce any statement by Alex Cox. Ooh, this is about the statement by Alex. Court outside the presence of the jury prior to attempted introduction of any statements of Alex Cox being introduced. After discussion, it is ordered granting the state's motion. The court finds all statements of Tylee Ryan to be hearsay. Oh, no. And that the defendant has not established that any specific statement is either non-hearsay or falls within the exception of hearsay. If, however, during the course of the trial, defendant believes a good faith exists under the law to introduce statements of Tylee Ryan, she shall first notify the court. Oh boy. Lori ain't gonna like that. Okay, it says here, discussion is held with respect to the state notice disclosure request for disclosure. The court informs the defendant that any witness, expert witness that is, needs to be disclosed as soon as possible. So that has to be by March 31st. Let's see, at 10:30 a.m. before the judge. Oh, good. So we got another hearing. Oh, I see what's going on here. Last day of the trial will be May 11th, 2025. Oh, okay. Hold on a minute. I'm going to see if they started yet. No. Again? Oh, God. No. Hold on. I'm going to pull up Court TV. Court TV. Why do they got it on that? All right. It happened again yesterday, too? Oh, Jesus. Okay, what's this? It is ordered denying the defendant's request to consolidate trials. Okay, so what Lori wanted to do, if you guys remember, is have both trials at the same time. The judge said no. Anything else? So there's going to be one pool camera and a still camera in the courtroom. You know, the same old that we know. Same old people. How is everybody today? Yesterday you didn't have any? Oh, it didn't happen. Oh, God, look at me. I can't even read right. Let me look into my YouTube studio here a minute. What is going on? Hold on. Where am I? I don't know. I'm just looking to see if there's anything I could do. Oh, shoot, I can't. Hmm. Hmm. Okay, maybe I can. Let's looky here. Uh, let's see if this works. Let's see if this works. I hope it works. Okay, let's see. Let's see. Just getting kids off to school. Good. All right. All right. Hold on a minute. Okay, there's two channels. I'm trying to figure out who to go through. I kind of want to go with the local channel out there in Arizona, channel 10 with Justin Lum. I like to go with the yeah, I think I will. I think I will. Let's see what Lori looks like today. I wonder if she could be all bossy. Yep. Where's everybody? Why ain't anybody talking? What kind of chat is this? Nobody wants to talk? I see how it is. Hi, Nicole. How you doing? We are just waiting. We are just waiting. All right. I'm going to have to get headphones on. No, I'm going to wait. You're feeding 5 dogs? Wow. Yeah, I'm good. Thank you. Thank you. Oh, just tired, that's all. Oh, Nala, what's wrong, Nala? Talking to my dog. Oh, you know what? I don't know, man. Watching her on Dateline, I'm like, wow. Now, mind you, people know I've had conversations with Lori, and there were some wow moments. I know, ain't that weird? At least Jody's kids were saved. Or I'm thinking of Ruby Frankie. Ruby, not Jody. Ruby the mama. We're doing a movie tonight, people. We are doing Trial by Fire um, at 6 p.m. Central Standard Time. And that will not be on YouTube because I'll get a strike. It will not be on Patreon. I will get a strike. And it will not be on Facebook because they take me down on there. But on Rumble they don't. And all I got to do is give you guys a link. You do not have to have an account to come watch. My brother did the fire alarm at the jail. He got a lovely glimpse of. No. Really? Oh boy. So they don't have Jody and Ruby in the same prison? Yeah, yeah, yeah. Why are they behind? What is going on in that courtroom? Is Lori acting up right now? Thank God I did not come in outer before. Oh, that's why you said that. I didn't know Jody was in Arizona. Yeah, keep those two demons away from each other. Oh, I gotta shut off my notifications, people. Well, this is what you do. You do not answer your phone for them. You let that voicemail pick it up. That's what you do, okay? Problem solved. Just like your boss. Your boss is a problem. And I might have to have a talk with your boss. You know, you got places to be besides work. Oh my god. You have places to be besides work, Misty. And your boss, I think, needs to know. Okay, I don't know what channel. Oh, it's Court TV that's in control. That's right. Okay, I put mine on silent and do not disturb, and what does happen? I don't even know what happens. Oh yeah, I don't see any calls. I think. Oh, Berkey, Nola. Hey, Misty. There's a three-part thing I want to watch of the 5 top mob families in New York. Would you be interested? It's 6 hours. I mean, we couldn't watch all 6 hours. I mean, come on now, right? It's a 6 hour special. I really want to watch it. I know. I love the mob. I would love to meet Michael Franzi. He was a boss in the Gambinos. I think it was the Gambinos. And of course, John Gotti. Who wouldn't want to meet John Gotti? Come on now. But he's dead. Gonna jump in the shower. Okay. You know what? You know what I think is really funny though. You got the mob guys, okay, like Michael, Sammy the Bulls on YouTube. They got YouTube channels, you guys. The mob bosses have YouTube channels, and then you got the rat, which we Sammy the Bull. He's no bull. Sammy is a rat, but and you got Chris Colombo. Can you believe that? Yes, we are. 6 p.m. Yes, we are. Yeah. And there's other ones too, but those are the main ones that I know. But there's way more of them on YouTube. Yes, Trial by Fire. That's going to be exciting. That one's going to be good. It's a true story, people. It's a true story about a guy in Texas that gets the death penalty. Right. Still nothing. Do you know who's in court right now? Karen Reed. Motions hearing because her trial's coming up. And then you know who else's trial's coming up? Brian Kohlberger. We're going to be busy with trials. And I wonder when Stephen or Stefan Stearns is. Stefan. He can just go in the wood chipper immediately. Yeah. Okay, I got a situation here, people.
Hi guys, can you hear me?
Yeah, bitch, I'm coming after you.
I'm always so shocked.
She's in trouble. Somebody's in trouble on the internet from me. Somebody is missing with Timmy. I'm going to bring attention to her. I'm going to be doing a live on her. Hold on a minute, people. We're going to her channel right now. She's coming after Timmy. Timmy is gone. She is accusing Timmy of being in the Delphi case. Here she is right here. She's talking about Timmy.
Get my phone.
He's Timmy D's, but they're using his picture and stuff.
Yeah, hold on a minute. Hold on a minute. I'm coming after you, just so you know. We are coming after you. Yeah, and I don't mean people in my chat. I mean other creators. You do not mess with the open investigation, lady. You have no idea what you're doing. Look at this.
Kid,
Where does she put Timmy's picture?
hello?
Where does she put Timmy's picture? Are you there? Hello? Oh my God. I'm so upset. I am so upset right now. Let me call Miss Barber back. I don't know why that happened. Who is she? Oldest. So she's only been around 10 months?
Your call has been forwarded to an...
Okay. Lori hasn't started yet. Lori hasn't started yet. I'm going to find out who this is. She's accusing Timmy. She's accusing Timmy, who was unalived, to have something to do with the Delphi case. Are you kidding me? Yes, yes, yes. Believe me, I'm coming back later after Lori, and I'm going to make it aware what's going on. You got Timmy, that's an unsolved homicide, and you got this lady accusing Timmy of harming these girls in the Delphi case. Are you kidding me? Who do these people think they are? This is somebody's child. This is somebody's kid that has not gotten justice. Are you kidding me? I'm going to write a little message to her. Oh, yes, I am. You people know how I get when people mess with families, victims. I become a mama bear, okay? I don't care who you are. I don't care if you're famous or not. I don't care. If I feel you're doing wrong, I'm coming for you. Okay? Okay. And I just might hurt your feelings. That's right. They have no idea how loved Timmy is. Whew, I gotta calm down, people. I gotta calm down. Wow. Oh my God. Oh God. You know what? Okay. This person. Hi, how are you? This person, mind you, I love real psychics, okay? She's a tarot reader. She's a tarot card reader. Okay, I gotta stop. I'm getting too. Mm-mm-mm. Can you guys help me calm down? You know what? There ain't no calming me down now. Okay. You know what I'll do? I'll start out nice. That's what I'll do. Yes, I love my tarot friends, which my sis, High Priestess Angelique, that's my girl. Here we go. Why can't we see anything?
They don't want me to when I ask them that. Yeah. That's fine. He'll be on this. Thank you. Hey, good morning.
All rise. All right, please be seated. This is State of Arizona versus Lori Daybell, CR 2021-001704.
Your Honor, for the record, this Trini K on behalf of the state, and for the record, the next of kin and the victim in the 2022 matter are appearing virtually.
All right.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy as advisory counsel for Ms. Daybell.
Go ahead and announce.
Lori Daybell.
All right, thank you. My courtroom assistant said there's some issue with advisory counsel at the table.
I apologize, Your Honor. I didn't think about the logistics, so I'll just let Ms. Daybell.
Okay.
Yeah, I was going to ask if I could have my investigator up here at the table, because if I needed to ask him something, then I need him available.
Yeah, any side can designate an investigator to sit with them through the trial and through court proceedings. So that you can have, if you can fit 3 chairs there, that's fine. Otherwise, advisory counsel could scoot her chair behind, whatever you think is logistically easier.
Appreciate it. Thank you, Your Honor.
All right. I just received word literally 2 minutes ago that we will be using Judge Kemp's courtroom, and we can use it for the entire first trial, which is in the South Court Tower, which will give us more space as needed. Have the parties, I had my staff drop off the proposed questionnaire on your table this morning. I know you just got it this morning. You may need some time to read through it. That's my proposed questionnaire. Obviously, there's maybe a lot more questions that either side would like to ask the potential jurors in follow-up. So this is not limiting what would be asked ultimately to the jurors. In addition to this, the questions in this questionnaire, when the potential jurors come in, I always go over the burden of proof. I go over credibility of witnesses in a little more detail, especially as it pertains to how people perceive officer testimony. And some other areas I'll highlight. So I intend on asking more than just what's in this questionnaire, but this questionnaire is intended to get through some of the bigger issues such as pretrial publicity or opinions people may have had or exposure to the case people may have had. And then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family members have been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I forgot, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify unless those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder. That's on my desk. Before we
Defense filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No.
Okay. All right, let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right, I'm gonna make an order and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. That makes Hicks, you look like you want to say something.
I don't know. No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew. All right, so I've read the defendant's disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own sub-right or extractions. So obviously the expert hasn't even begun work, let alone they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay.
And
When you
Joe-
say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these
Well,
people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute out as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is the Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the cell-right extraction already for that requested item that's been in defense possession for however long now.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Your Honor, I would ask leave that depending on what Mr. Dworkin says, that
Well,
would
it
put
could
this,
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance,
No, from getting things done in an effective and quick manner.
all right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm gonna have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
I also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
Your
From
Honor,
this-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask
well-
for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium.
Mhm.
We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting my
copies
paralegals
for the
very
state.
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out, I think we said, next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday, the 24th, and will end on Monday, the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection, whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday, the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be the starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is, for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or
Who do you want me to, I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or Or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name, Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do
Department.
another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
Oh, so there's that. All right, so Lori here. Do you think this is going to be another Daryl Brooks? She got attitude. She got attitude with the judge. Okay, but I gotta go, people, because I got a situation. I need to help family out. I'm going to be back, Misty. I need you here. We need to be here for Miss Barbara because somebody is coming for her deceased son. That it's an unsolved homicide. Her son, and somebody is using her name, stating that her son has something to do with the Delphi case. So I need to take care of the situation. Okay. I'm going to get a hold of her as soon as I get off live, and I'm going to find out who these people are doing this. Okay. Love you guys. Bye-bye.